this is my framing of some of the initial key Supreme Court decisions in the area of defining commercial speech and the standards for its regulation. So we start with the Virginia pharmacy case, which is the forerunner to Central Hudson, the first clear statement that commercial speech is protected by the First Amendment. And here we have a political and economic theory adopted by the Supreme Court. The free flow of commercial information is indispensable not only to the proper allocation of resources in a free enterprise system, but also to the formation of intelligent opinions as to how that system ought to be regulated or altered. The first claim is an economic theory, and it leads us to one core question in this area, which is, does regulating advertising constitute the regulation of speech or the regulation of economic activity? This makes a huge difference to what is going to survive review as long as Lochner remains bad law. Also, note, how exactly does advertising help form intelligent opinions about how the system of free enterprise ought to be regulated or altered? Does advertising help form these opinions more or differently than, say, being paid a wage, making a product? If so, are those entitled to First Amendment protection too? If not, what is this rationale doing? So this is the background and sets the stage for Central Hudson. So I want to start in Central Hudson with what the government was trying to accomplish, to decrease energy use and ideally the price of energy because they have lower demand for it. There were more direct ways of doing both of these things. You could have limited individual consumption to certain hours or to certain amounts. And the question is, why didn't they do that, which would definitely have worked to decrease energy consumption rather than just tinkering with advertising? The intuition that many people share is that banning ads is often a political compromise compared to more painful and unpopular direct interventions. You can compare this to the concept of nudges, if you have encountered that. The First Amendment might force the government to forego some nudges and commit to a regulatory strategy. And one question to consider is there anything wrong with political compromise when it's focused on ads? We often compromise with less effective measures of regulation because there's political opposition. Is there something particularly wrong with that when it's regulating commercial speech? You can also think about commercial cigarette regulation, which also had that element of compromise rather than banning cigarettes outright. So we get from Central Hudson definitions of commercial speech, which are necessary if we're going to have a different standard for evaluating the constitutionality of regulations of commercial speech as distinct from regulations of political speech. So the first definition the court gives is expression related solely to the economic interests of the speaker and its audience. This one is an extremely rough cut for reasons that should be obvious. For example, when Starbucks or Abercrombie and Fitch tries to get you to buy fair trade coffee or organic cotton, they're not necessarily engaging in speech related solely to their and your economic interests. So the court is immediately aware that's probably too rough. The next definition that we get is speech proposing a commercial transaction. To which Stevens objects as potentially over and under inclusive. Courts have generally found speech proposing a commercial transaction to be too narrow, or at least they've interpreted what it means to propose a commercial transaction very broadly, as we will quickly see. My preferred reading of this, by the way, is that there's a distinction between speech that is itself the product being sold, which is non-commercial, and speech that is selling something else, which is commercial. That is how I would prefer to formulate it, but as far as I know, nobody has put it in a case that distinctly yet. I live in hope. Okay, put aside for a moment the definition of commercial speech and the justification for protecting it. How are regulations of speech to be judged? We get the four-part test known as the Central Hudson test. The commercial speech must concern lawful activity and not be misleading. The key implication here, interestingly not fully stated outright, is that false and misleading commercial speech may simply be banned. This is noticeable. It's the biggest difference between commercial and political speech. Political speech cannot be banned just because it's false or misleading. One suggestion from theorists about why this distinction is justified is that there's no independent autonomy interest of the commercial speaker in speaking, only an interest of the consumer in being informed. Therefore, there's no separate interest in being allowed to speak falsely. Notice how vital this formulation makes the difference between misleading and non-misleading commercial speech. If misleading speech receives no constitutional protection, then one key question is whether the legislature can find as a fact that certain forms of advertising are false or misleading. For example, using bright colors in cigarette ads to make them seem healthful, or failing to disclose that a fetus is a human being. The key question for you to form an opinion on is when, if ever, should the courts defer to the legislature when the legislature determines that some statement or omission is misleading? And more generally, what gives the government, either in the form of a regulator or a court, the right to determine the truth? So the first prong is different because it decides whether the speech is within the First Amendment at all. If it is within the First Amendment, then the other three prongs govern the government regulation. So we ask whether the asserted government interest is substantial. Very few constraints on this. Courts rarely find that interests aren't substantial. Instead, the regulation comes from, or the bite of Central Hudson comes from 3 and 4, whether the regulation directly advances the government interest asserted, and whether it's more extensive than necessary to serve that interest. There's a profound difference between the standard and the standard for political speech. It's essentially impossible to regulate non-misleading political speech. Even when it comes to falsehood, we usually refer political falsehoods to the marketplace of ideas, leaving any constraints to listener skepticism and other forms of self-correction. There are several common justifications for this divide. First, commercial speakers have extensive knowledge of both the market and their products, so they're well situated to evaluate the accuracy of their messages and the lawfulness of the underlying activity. This isn't a very strong argument, though. There are many cases of scientific uncertainty, and many claims are comparative, meaning that knowledge of one's own products isn't actually sufficient for verification. Second reason, commercial speech is the offspring of economic self-interest. It is a hardy breed of expression that isn't particularly susceptible to being crushed by overbroad regulation. Again, this might not do a great job of distinguishing commercial speech from other kinds of speech that receive much more protection. Religious proselytization is often very hardy. People have accepted martyrdom in order to spread the word. That might be thought to imply we don't need to worry about punishing people for going too far because they won't be chilled. So no, that's generally not the most persuasive reason. There's a footnote in Central Hudson which says, if we don't allow more regulation of commercial speech and we force all speech regulation to meet the same strict standard, we'll be very tempted to dilute the protection of all speech, given the compelling reasons the government has for regulating commercial speech to protect consumers against fraud and sometimes even death. This might be the truest reason. It rests on an empirical prediction, what will happen to doctrine, that the Supreme Court is actually in a very good position to make, and much better than other empirical claims. Meanwhile, Justice Stevens developed a theory looking at the purpose of regulation. The state's power, he reasoned, to regulate commercial transactions justifies a power to protect consumers in those transactions. Thus, if a regulation's purpose is to pursue some goal outside the commercial transaction, for example, decreasing energy consumption, which was Central Hudson's purpose, it would be tested by the tough standards that generally apply to speech regulation, strict scrutiny. On the other hand, if the purpose of the regulation is to preserve a fair bargaining process, it would be treated like an economic regulation and given only rational basis review. I am very sympathetic to this approach, but it may also prove hard to apply. For example, if the regulatory theory is that consumers are being duped into consuming more than they really want to by advertising if they knew the truth, or are wrongly convinced, for example, that cigarettes are cool. The question that you have to answer is that really about preserving a fair bargaining process, or is that just a decision the government doesn't want you to make, which is a classically bad reason for a speech regulation? So that's my introduction to Central Hudson, and I will see you in class.